Constitution of Michigan of 1963. We, the people of the state of Michigan, grateful to Almighty God for the blessings of freedom, and earnestly desiring to secure these blessings undiminished to ourselves and our posterity, do ordain and establish this Constitution. Article 1, Section 1. All political power is inherent in the people. Government is instituted for their equal benefit, security, and protection. Section 2. No person shall be denied the equal protection of the laws, nor shall any person be denied the enjoyment of his civil or political rights, or be discriminated against in the exercise thereof because of religion, race, color, or national origin. The legislature shall implement this section by appropriate legislation. Section 3. The people have the right peaceably to assemble, to consult for the common good, to instruct their representatives, and to petition the government for redress of grievances. Section 4. Every person shall be at liberty to worship God according to the dictates of his own conscience. No person shall be compelled to attend, or against his consent, to contribute to the erection or support of any place of religious worship, or to pay tithes, taxes, or other rates for the support of any minister of the gospel or teacher of religion. No money shall be appropriated or drawn from the treasury for the benefit of any religious sect or society, theological or religious seminary, nor shall property belonging to the state be appropriated for any such purpose. The civil and political rights, privileges, and capacities of no person shall be diminished or enlarged on account of his religious belief. Section 5. Every person may freely speak, write, express, and publish his views on all subjects, being responsible for the abuse of such right. And no law shall be enacted to restrain or abridge the liberty of speech or of the press. Section 6. Every person has a right to keep and bear arms for the defense of himself and the state. Section 7. The military shall in all cases and at all times be in strict subordination to the civil power. Section 8. No soldier shall in time of peace be quartered in any house without the consent of the owner or occupant, nor in time of war, except in a manner prescribed by law. Section 9. Neither slavery nor involuntary servitude, unless for the punishment of crime, shall ever be tolerated in this state. Section 10. No bill of attainder, ex post facto law, or law impairing the obligation of contract shall be enacted. Section 11. The person, houses, papers, possessions, electronic data, and electronic communications of every person shall be secure from unreasonable searches and seizures. No warrant to search any place or to seize any person or things or to access electronic data or electronic communications shall issue without describing them, nor without probable cause, supported by oath or affirmation. The provisions of this section shall not be construed to bar from evidence in any criminal proceeding any narcotic, drug, firearm, bomb, explosive, or any other dangerous weapon seized by a peace officer outside the curtilage of any dwelling house in this state. Section 12. The privilege of the writ of habeas corpus shall not be suspended, unless in case of rebellion or invasion, the public safety may require it. Section 13. A suitor in any court of this state has the right to prosecute or defend his suit, either in his own proper person or by an attorney. Section 14. The right of trial by jury shall remain, but shall be waived in all civil cases unless demanded by one of the parties in the manner prescribed by law. In all civil cases tried by 12 jurors, a verdict shall be received when 10 jurors agree. Section 15. No person shall be subject for the same offense to be twice put in jeopardy. All persons shall before conviction be bailable by sufficient sureties, except that bail may be denied for the following persons when the proof is evident, or the presumption great. A. A person who within the 15 years immediately preceding a motion for bail pending the disposition of an indictment for a violent felony, or of an arraignment on a warrant charging a violent felony, has been convicted of 2 or more violent felonies under the laws of this state, or under substantially similar laws of the United States or another state, or combination thereof, only if the prior felony convictions arose out of at least 2 separate incidents, events, or transactions. B. A person who is indicted for or arraigned on a warrant charging murder or treason. C. A person who is indicted for or arraigned on a warrant charging criminal sexual conduct in the first degree, armed robbery, or kidnapping with the intent to extort money or other valuable thing thereby, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person. D. A person who is indicted for or arraigned on a warrant charging a violent felony, which is alleged to have been committed while the person was on bail, pending the disposition of a prior violent felony charge, or while the person was on probation or parole as a result of a prior conviction for a violent felony. If a person is denied admission to bail under this section, the trial of the person shall be commenced not more than 90 days after the date on which admission to bail is denied. If the trial is not commenced within 90 days after the date on which admission to bail is denied, and the delay is not attributable to the defense, the court shall immediately schedule a bail hearing and shall set the amount of bail for the person. As used in this section, violent felony means a felony, an element of which involves a violent act or threat of a violent act against any other person. This section, as amended, shall not take effect until May 1st, 1979. Section 16. Excessive bail shall not be required. Excessive fine shall not be imposed. Cruel or unusual punishment shall not be inflicted, nor shall witnesses be unreasonably detained. Section 17. No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. The right of all individuals, firms, corporations, and voluntary associations to fair and just treatment in the course of legislative and executive investigations and hearings shall not be infringed. Section 18. No person shall be rendered incompetent to be a witness on account of his opinions on matters of religious belief. Section 19. In all prosecutions for libels, the truth may be given in evidence to the jury, and, if it appears to the jury that the matter charged as libelous is true, and was published with good motives, and for justifiable ends, the accused shall be acquitted. Section 20. In every criminal prosecution, the accused shall have the right to a speedy and public trial by an impartial jury, which may consist of less than 12 jurors in prosecutions for misdemeanors punishable by imprisonment for not more than 1 year, to be informed of the nature of the accusation, to be confronted with the witnesses against him or her, to have compulsory process for obtaining witnesses in his or her favor, to have the assistance of counsel for his or her defense, to have an appeal as a matter of right, except as provided by law, an appeal by an accused who pleads guilty or nolo contendere, shall be by leave of the court, and as provided by law, when the trial court so orders, to have such reasonable assistance as may be necessary to perfect and prosecute an appeal. Section 21. No person shall be imprisoned for debt arising out of or founded on contract, express or implied, except in cases of fraud or breach of trust. Section 22. Treason against the state shall consist only in levying war against it, or in adhering to its enemies, giving them aid and comfort. No person shall be convicted of treason unless upon the testimony of 2 witnesses to the same overt act, or on confession in open court. Section 23. The enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Section 24. Crime victims, as defined by law, shall have the following rights, as provided by law. The right to be treated with fairness and respect for their dignity and privacy throughout the criminal justice process. The right to timely disposition of the case following arrest of the accused. The right to be reasonably protected from the accused throughout the criminal justice process. The right to notification of court proceedings. The right to attend trial and all other court proceedings the accused has the right to attend. The right to confer with the prosecution. The right to make a statement to the court at sentencing. The right to restitution. The right to information about the conviction, sentence, imprisonment, and release of the accused. The legislature may provide by law for the enforcement of this section. The legislature may provide for an assessment against convicted defendants to pay for crime victims' rights. Section 25. To secure and preserve the benefits of marriage for our society and for future generations of children. The union of one man and one woman in marriage shall be the only agreement recognized as a marriage or similar union for any purpose. Section 26. The University of Michigan, Michigan State University, Wayne State University, and any other public college or university, community college, or school district shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. 2. The state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. 3. For the purposes of this section, state includes, but is not necessarily limited to, the state itself, any city, county, any public college, university, or community college, school district, or other political subdivision or governmental instrumentality of or within the state of Michigan, not included in subsection 1. 4. This section does not prohibit action that must be taken to establish or maintain eligibility for any federal program, if ineligibility would result in a loss of federal funds to the state. 5. Nothing in this section shall be interpreted as prohibiting bona fide qualifications based on sex that are reasonably necessary to the normal operation of public employment, public education, or public contracting. 6. The remedies available for violations of this section shall be the same, regardless of the injured party's race, sex, color, ethnicity, or national origin, as are otherwise available for violations of Michigan anti-discrimination law. 7. This section shall be self-executing. If any part or parts of this section are found to be in conflict with the United States Constitution or federal law, the section shall be implemented to the maximum extent that the United States Constitution and federal law permit. Any provision held invalid shall be severable from the remaining portions of this section. 8. This section applies only to action taken after the effective date of this section. 9. This section does not invalidate any court order or consent decree that is in force as of the effective date of this section. Section 27. 1. Nothing in this section shall alter Michigan's current prohibition on human cloning. 2. To ensure that Michigan citizens have access to its stem cell therapies and cures, and to ensure that physicians and researchers can conduct the most promising forms of medical research in this state, and that all such research is conducted safely and ethically, any research permitted under federal law on human embryos may be conducted in Michigan, subject to the requirements of federal law, and only the following additional limitations and requirements. A. No stem cells may be taken from a human embryo more than 14 days after cell division begins, provided, however, the time during which an embryo is frozen does not count against this 14-day limit. B. The human embryos were created for the purpose of fertility treatment, and with voluntary and informed consent, documented in writing, the person seeking fertility treatment chose to donate the embryos for research, and 1. The embryos were in excess of the clinical need of the person seeking the fertility treatment and would otherwise be discarded unless they are used for research, or 2. The embryos were not suitable for implementation and would otherwise be discarded unless they are used for research. C. No person may, for valuable consideration, purchase or sell human embryos for stem cell research or stem cell therapies and cures. D. All stem cell research and all stem cell therapies and cures must be conducted and provided in accordance with state and local laws of general applicability, including but not limited to laws concerning scientific and medical practices and patient safety and privacy, to the extent that any such laws do not 1. Prevent, restrict, obstruct, or discourage any stem cell research or stem cell therapies and cures that are permitted by the provisions of this section, or 2. Create disincentives for any person to engage in or otherwise associate with such research or therapies or cures. 3. Any provision of this section held unconstitutional shall be severable from the remaining portions of this section. Section 28. Every individual has a fundamental right to reproductive freedom, which entails the right to make and effectuate decisions about all matters relating to pregnancy, including, but not limited to, prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. An individual's right to reproductive freedom shall not be denied, burdened, nor infringed upon unless justified by compelling state interest achieved by the least restrictive means. Notwithstanding the above, the state may regulate the provision of abortion care after fetal viability, provided that in no circumstances shall the state prohibit an abortion that in the professional judgment of an attending healthcare professional is medically indicated to protect the life or physical or mental health of the pregnant individual. 2. The state shall not discriminate in the protection or enforcement of this fundamental right. 3. The state shall not penalize, prosecute, or otherwise take adverse action against an individual based on their actual, potential, perceived, or alleged pregnancy outcomes, including but not limited to miscarriage, stillbirth, or abortion. Nor shall the state penalize, prosecute, or otherwise take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. 4. For the purposes of this section, a state interest is compelling only if it is for the limited purpose of protecting the health of an individual seeking care, consistent with accepted clinical standards of practice and evidence-based medicine, and is not infringed on that individual's autonomous decision-making. Fetal viability means the point in pregnancy when, in the professional judgment of an attending healthcare professional, and based on the particular facts of the case, there is a significant likelihood of the fetus's sustained survival outside the uterus, without the application of extraordinary medical measures. 5. This section shall be self-executing. Any provision of this section held invalid shall be severable from the remaining portions of this section.